The waiver. Hi, I'm Darren Findling of the Probate Pro. We're going to cover the SCAO form PC 561. This form, SCAO, S-C-A-O, State Court Administrative Order, PC for Probate Court, 561, it's the form number. You're welcome to contact my office. We'd be happy to give you one free of charge. This form is created by various statutes and court rules, like all of the SCAO forms. If you look at the bottom right corner of these forms, it tells you the form, as well as on the bottom right corner, the statute or any court rules that are relevant to the form. With all of these forms, we strongly urge you to be working with a skilled, competent probate lawyer to understand how to fill it out, to understand when to use it and when not to use it, and to understand the nuances, because this particular form can be used in a variety of contexts. It can be used in a guardianship, conservatorship, deceased estate trust file. It can be used in various forms. So to understand when to use it is really critical. Now, the idea of a waiver and a consent, it's kind of intuitive. You're waiving your rights. You're consenting to something. So the idea is anytime that you are consenting to something that's being requested or waiving your right, this would be the form that you'd be considering to use. Now, as I mentioned, the statute 700.4 or 1402 provides that except as provided in a very particular circumstance, a person, including a guardian ad litem, conservator, or other fiduciary, can consent to notice of the granting of a petition. A petition is a request of the court to do something. So for example, if somebody files a petition for sale of real estate and you agree, you can consent. If somebody files a request of the court to do something and you simply say, I'm waiving my rights as it relates to it, you can fill out the waiver and consent form. And when you fill this out, it is giving the court an understanding that although you may not be appearing at the court hearing, you may not be filing anything with the court, you are asserting to the court that you agree or consent to that which is being requested. Now, I mentioned that there are certain circumstances where it's not permissible. So one, this is not the form that you use when you're doing an application for informal probate. If you're consenting, that form is a renunciation of your right to serve as personal representative. So you don't use a waiver and consent in an application for informal probate process. You also, if often people will get confused that they say, well, I'm in a family situation and I had one of my family members consent to my appointment as personal representative. That does not mean that you're giving up your rights to receive your inheritance. So often people will say, well, Darren, they signed a consent. And I said, yes, they signed a consent to being the personal representative, not to release their interest or their rights to receive their interest in the home, but rather consenting to the appointment of the personal representative. In addition, under a guardianship context, the ward or protected individual cannot waive notice. So there is no release or waiver in that particular situation. So there is still a requirement to serve and give notice to ensure that those people are protected. So let's walk our way through this particular form and when it may be used. And I had mentioned also the Court Rule 5.104. That is the general court rule that also addresses service and who may not waive. And it speaks about a legally who may consent. A legally competent interested person can. A person designated as eligible to receive notice on behalf of an interested person who is a legally disabled person, or on behalf of a person, an interested person, whether competent or legally disabled, by an attorney who has previously filed a written appearance. So for example, if somebody has stood in the shoes as an attorney, they could also use the consent. But again, it provides for this exception. It says, however, a guardian, conservator, or trustee cannot waive or consent with regards to petitions, motions, accounts, or reports made by that person as guardian, conservator, or trustee. So there's this carve out. So again, to understand its use, please be working with a skilled, competent probate attorney to make sure that you know how to complete the form, when it's appropriately used. Because again, there's a lot of things at stake here. And when you go and you fill this form out, and only to learn you get to court, and there's a problem with it, and then it delays things and causes some great frustration among the participants. Top left corner is the county. Top right corner is the file number. In the matter of would be just simply the estate of. It may be a deceased estate, a conservatorship, etc. Here, under Section 1, you're identifying in what role, what capacity are you consenting. So, for example, are you consenting as an heir? Are you consenting as an interested person? So you identify the role upon which you're consenting. Section 2 identifies whether you're waiving your right to receive notice of a hearing, and here you get to specify. So for example, if the petition, as I used earlier, is a request to sell real estate, and you're consenting to it, you would write petition for approval of sale of real estate. You want to be very particular here and very clear to the court so that the court is aware of what you're consenting to. Be very specific and very limiting if necessary, or very expansive if necessary. And it mentions that you're declaring that you have received a copy of it. So you're not just signing this in blank. Never should you sign any of these probate forms in blank, especially when you're consenting to something. So here there's a declaration that you received a copy of the petition that you're consenting to. Section 3 may be just simply if you're waiving notice of the hearing. So if you're saying, well, I'm not waiving notice and consenting, but I'm simply waiving the notice as it relates to the hearing itself. So again, this form used in a lot of contexts, in a lot of circumstances, to understand when to use it and how to fill it out. It's very, very, I strongly urge you to be working with an attorney when you're doing so. Bottom section, right side, signature information, information of the person that's signing it. Left side, if there's an attorney that's involved, would sign it there. Now you can see that statute speaks of a waiver pursuant to 700.3310. These are, again, carve-outs to the use of this particular consent. So think of it like you're stipulating, you're agreeing, you're consenting, you're waiving. These are the general times that this particular SCAO form is used. At the Probate Pro, we are passionate about everything probate. If you have a question about this particular form or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.